everyone. Welcome to the Town of Carmel Zoning Board of Appeals meeting for January 2021. Happy New Year to everyone. The board members' names are in front of you on the podium. Greg Fulchetti's Town Council is with us this evening. The way we operate is we will hear the case. I'll ask you to come up. I'll swear you in unless you're counsel. We'll swear you in, and you tell us what your situation is, and we'll judge amongst the board members or ask questions, and then we'll open it up to the public. Once the public part of it is closed, there's no further input from the public on an application, so please keep that in mind. It looks like it's going to be a long night, so I'd ask anyone who is in the public who wishes to speak on any application to keep it brief and to the point. In fairness to the other applicants here this evening. Will you all please join me for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Reminder, we're still dealing with COVID-19, so I'd ask that when you come up to the podium and speak clearly and concisely into the microphone. You don't need your mask. I'd actually prefer that you don't, so we can pick it up on record. This is being recorded for minutes and public record. And in between, if you don't mind just using the hand sanitizer and cleaning up kind of as you go. If you are going to come up and speak, please, on any application, please sign your name and address on the paper that's on the side of the podium. All right. Our first application is a holdover from last month. It's for Mayhoven LLC for variation of section 156-15, seeking permission to construct a bathhouse, pergola, rain garden, and extend dock. The property is located at 737 South Lake Boulevard in Hopac, New York. Tax map 75.42-1-13. And Joel, you'll be representing. Gentlemen, both raise your right hand. So state your name and address for the record first.
Joel Greenberg, 2 Mustard Road North, Mahopac, New York.
Oh. And you are, sir?
Lubomir Canetti, 405 Grand Terrace, Mamaroneck, New York.
Dominic, I don't know if that microphone is on. I mean, just check the switch. Just blow into it.
It's on.
Is it on? Okay. All right. So, when you guys were here last month, we requested or suggested some changes to appease. Oh, raise your right hand. Thanks, Sylvia. Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
Okay. Thank you. So bring us through what changes you made. And
obviously, we heard the comments and the concerns of the board at the last meeting, and what we've done basically is to reduce the size. I believe that the pergola didn't seem to be a problem with most of the board members, and the concern was the size of the bathhouse. So what we did was basically reduce the size of the bathhouse, so it is now only 6 feet wide. We have at least 4 feet to the property lines on either side, and the bathhouse will now just wind its way and find out and end at the pergola. So I think we've listened to the concerns, and I think we've addressed them. And if you have any further questions, I'll be happy to try to answer them.
all right, and I see it was centered now to allow for emergency egress
Yes.
to get to the water, which I'm sure appeases the neighbors next door as well. So I'll open it up to the board.
Yeah,
Silvio?
just so
Oh, sorry.
get into the record, we did contact Bert Melchner, who was the next-door neighbor who was here at the last meeting, and he is aware of the change.
Okay.
And he's okay
Obviously,
with it,
he'd
Joel?
be here.
He said thank you.
Yes, he said he thanked us.
If he still had anything further, I'm sure he'd be here.
He would
So,
be here.
Silvio, anything?
No, you did everything we wanted,
Phil?
Joel, so thank you.
No questions. Thank you. Rose?
I thought we asked you to shift it closer to the fence.
No, I think the whole idea was to have 2 wide areas on either side so that you could have access on either side of the bathhouse.
I was under the impression that we wanted to shift it over so that
Well-
you could have a better view. Does anyone else?
No, it was, it looks like he did what was sort of requested by Bert and even the board to center it.
Right.
And give space on either side. And he adjusted the layout here.
Yes.
So
I
it was,
thought John had discussed it, and he said move it closer to the fence? Did we say
No,
that?
I think this is,
Okay.
it looks, he changed it.
He did narrow it.
Yeah,
By how
was-
it
much?
was close, it
2
was
feet, yeah.
closer.
2 feet?
Yeah. It's narrow, and of course, there's more space on either side.
Yeah.
all right, so.
It was closer to the fence.
It was close, that's right. Maybe that's what you mean. It was closer to the fence, and we moved it, so now there's 4
Closer.
feet of space on either side.
Yeah, I thought it was 4 and 2 before?
Before, now it's 4 and 4.
Okay.
Okay?
All right, is there any input from the public on this application? I'll look for a motion to close the public hearing.
Motion to close.
Do I have a second? All in favor?
Aye. Thank you very much.
Thank you, guys.
Bye, Joel. Thank you.
All right, number 2 this evening is Galeno Enterprises LLC, seeking interpretation that the CO issued for upstairs residential apartment remains valid in that the temporary conversion to office use involved no structural alterations. Further, a mixed-use entitlement was in existence per the zoning code at the time of the conversion. In the alternative, applicant seeks a use variance to permit a mixed use in C-zone. The property is located at 95 Glenida Avenue, Carmel, New York, tax map 44.13-2-16. Gentlemen, good evening. Bill, I don't need to swear you in. You're going to be speaking, sir? I'll swear you in just for the hell of it. State your name and address for the record,
Michael Gelino, 21 Wetherill, Brewster, New York.
and raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
Thank you.
Good
All right, Bill.
evening.
Good evening.
I guess to start, I want to show the board the notice that we placed in front of the structure. I wanted to show the board a typical day of clutter in the parking lot for the structure. And then I wanted to emphasize to you the law in which we're seeking the zoning board to employ to grant the relief that we are requesting. My name is William Schilling. With me is Michael Gelino, who is a managing member of Gelino Enterprises LLC, and that's the applicant here. The property we're talking about is 95 Glenida. It's in a commercial zone. It was built in 1957 as a mixed use. The upstairs received a CO for residence, the downstairs for office space. The downstairs consists of 2,700 square feet, the upstairs of 1,100 square feet. There are 6 commercial units downstairs, and there's 1 3-bedroom apartment upstairs. There are 12 parking spaces in this predated site. My thinking is that if it were to code, it would be at least 18. We're seeking your relief pursuant to 267B of the town law, which provides that the ZBA has the authority to overturn or to reverse a decision by an administrative official. In this case, it's the building inspector. There is a 1957 certificate of occupancy for a residence upstairs. The building inspector in 2017 issued a CO to retain an office on the 2nd floor, and it's on that basis that he believes, his opinion is, the residential CO is no longer valid. Our position is that the residential CO is still effective, it's still in place. Currently on the site on 95 Glenida Avenue is an existing apartment in a mixed-use structure. That is a permitted use in the C zone. That's what we have here, and that, as I said, is permitted by code. We believe that the CO issued by the building inspector was ministerial in nature and didn't invalidate the 1957 CO. In the alternative, we'll seek a use variance. Now, the use variance is a little bit strange because the relief we will be seeking, that is to put a residence upstairs, is a permitted use in that code. It's very strange that we would have to come here to seek a use variance to get a use that's permitted in your code. It's something I've never come across before, but that's the case here. Briefly, the facts are, you all know Glenida Avenue, and you all know the limitations of parking on Glenida Avenue. Glenida Avenue is filled with mixed uses, mostly residential in appearance. Most of them have substandard parking. Most of them have residences down upstairs and commercial upstairs. You cannot, the parking lots for these residential and commercial uses, the parking lots cannot countenance a complete commercial use. It's impossible because the lots are so small. And that's why I think the framers thought that these mixed uses were perfect in this zone. You could have offices and such downstairs and still accommodate residences upstairs and have a parking lot that won't be filled. You can't have any of these parking lots countenance a full commercial use. They're simply not big enough. And that's why I think the framers permit these uses in this code. The subject property was built in 1957 with a residence upstairs and an office downstairs. Both of them received COs. It was a mixed use until 1997, at least 1997, when the Rombergs passed away. We know that in 2004, Coppola purchased the property. And the period 5 years between 97 and her purchase are unknown, but we believe there was some residential use. In 2008, Rick Cowell rented the residence upstairs, used it as his office, and rented out a couple of units downstairs as well. But his affidavit, and if you could pass these, Mike, his affidavit says that it was a residential apartment when he went in, and it was a residential apartment when he left in 2016. There were no structural changes. There was no recompartmentalization. The kitchen had all the appliances. The bathroom had a full shower. It was a full apartment, a 3-bedroom apartment when he went in, a 3-bedroom apartment when he went out. That's what his affidavit said, and it's important because the residential flavor of the unit remained the same throughout. In 2017, Coppola sold to my client. Just before the selling, there was an administrative municipal problem, and that is there was no discussion as to the upstairs and what it was. And under 5910 of your code, you have to send the building inspector up when there's a change of use, and Michael went up and he said that they have the right to retain the office. That's what the certificate of occupancy says. The CO was issued clearly to effectuate the closing. It was not a structural thing. There was no structural component to the CO. Nobody was recompartmentalizing. It was just to retain the office. 5910 of your code says that no change of use of an existing building, no change of use of an existing building can be made unless a CO is authorizing that change. That's why Mike went. And he went there, and for the first time from 1957 all the way to 2017, it's unclear that the town ever knew that it shifted for a few years. But for the first time, Michael issues a CO saying, and this is all the CO says, that they can retain the office. Nowhere is there any invalidation of the 1957 CO for the residents upstairs. When my client purchased, prior to his purchase, he relied on the listing that says this can be used as an office or as a residence, and I'll pass these over. My client knew of the residential CO and believed that he could make that happen. However, he did try to rent it commercially for the first 3 or 4 months. Because of the logistics of the parking, because of a lot of things, he rented to a family, and that same family is still there today as we speak. As I said, there are 6 units downstairs. 2 are vacant, and 2 others are, my client takes one, he has his office there. And 2 have chosen not to renew, and whether or not they renew, we don't know. But the big problem has always been the parking. I've given you a P&L statement showing that without the residential income and given the 2 facts, the 2 vacancies, my client simply is not making his ends meet here. I have letters from every tenant on the property, employees and owners, to ask the zoning board to please keep the upstairs residence a residence, because if it were commercial, it would just backlog the parking lot to an extent it wouldn't be functioning. I told you that the code, if this were brought up to date, it would require at least 17 parking spaces, and so the parking lot is depicted there is a terrible way, and it's the reason Rick Cowell said that he left, because when he had closings, he had to send people down to the firehouse or to the TD branch because there wasn't enough parking. It's significant also for me to tell you that if you count the tenants, the owners, and the employees, 11 spots are taken, leaving only 1, which is the handicap spot for customers or patrons or clients. So the parking lot is the big dilemma here for future advancement of this commercial establishment. 1 spot for all the tenants, and for all the, for the tenants' customers is simply not enough. On the issue of the law, I want you please to pay attention to 267B of the town law. And it says, the zoning board may reverse a decision of an administrative official and make such an interpretation as, in its opinion, ought to have been made, and to that end shall have the powers of the administrative official from whose order the appeal is taken. Simply stated, this is your job and this is your obligation. If you find an irregularity or if you disagree with the decision of an administrative official, it's your job, in your discretion, in your judgment, to reverse it. And that's why we're here today, and that's why we believe we can make a case to you that the decision was wrong. Our position is simply this, that there are many reasons why this 57 CO should not be considered invalidated. First of all, it's a CO. It stays in place. And it was not specifically addressed in the 2017 CO. Having the right to do residences there isn't diametrically opposed to being able to retain an office. You should do it fine for us because the residential use existed from 45 to 50 years. You should fine for us because the 2017 CO was administrative in nature. Just send the building department up because there was a change of use from residence to office during that time frame. And again, 5910 of your code says if there is a change of use, it has to be evidenced by a CO. You should find the interpretation we're seeking because there's no structural changes. That kitchen which existed in 1957 is the same kitchen that exists right now.
Except for the appliances.
Sorry?
Except for the appliances.
No, the appliances are the same too.
Right. It's the same. It hasn't been changed at all, and that's found in Cal's affidavit as well.
Yes.
You should find for us because the code provides that this is a permitted use. It's a desired use because of Glenida Avenue and because of the limitations of parking all throughout Glenida Avenue and the fact there's very little place to park on Glenida Avenue. You should find for us because there's no invalidation of the old CO. The residential CO still stands today and was not in any way confronted by Mike's CO. And if there is ambiguity, you lawyers know the ambiguity has to be addressed to our favor as opposed to the town's favor. And finally, you should find for us because the case law and the law, the town law, all provides that you have the right to overturn a building department's decision. And it says specifically, if there is a CO first and then a second, it doesn't necessarily mean that the first one is invalidated. It's all a question of a totality of fact consideration, which I hope I give you this evening. As a practical matter, if you don't find for us, my client will have to go to the planning board, spend engineering fees, consulting fees, application fees, time, and then go back to the zoning board for the dimensional variance that this lot and this structure would obviously need, it being so old. Then, after successfully going to the zoning board, go back to the planning board for site plan approval. That is such a ridiculous manner or mode of direction in this matter. This site has been in existence since 1957. Nothing has changed. And to make my client go through all that just to get a residential tenant in there when there's a residential CO strikes me to be, I hope it's an affront to your judgment, because it is an affront to mine. If you want to, and if you will, hear my criteria of use variance, I'll be very quick. I think I've mentioned all of the factors, but I'll do it real quick. There's no chance for a reasonable return. The virus, together with the parking, my client cannot get a commercial tenant in there. And I have a prospective tenant who felt compelled to write a letter to you saying, there's no way I'm going to go there if there's more commercial space upstairs, and if you pass that around. So I believe reasonable return with the P&L is persuasive that he can't make a reasonable return. It's unique. It's 50 years of being in place. It's a residential site. It's a permitted use, all those things. I believe the neighborhood is the strongest criteria. The neighborhood is the same. It's not changing at all, but my client has improved the premises over the years that he's owned it, and it's not self-created. My client relied on a residential CO. He relied on a listing that said you could use it as a residence. He tried to rent it as a commercial space with no such luck because of the size of the parking lot. So it's not self-created. We meet all the factors of a use variance. If you find against us for the interpretation but find for a use variance, we still have to go to the planning board for that ridiculous, unnecessary stuff that's involved with going planning, zoning, and back to planning for a site that's been in existence and a scheme that's been in existence for such a long time. I just want to ask you to avoid the unconscionable and unnecessary part of this where my client, who in large part is a victim in my opinion, would have to do all those things just to put a residential tenant in there when there's a CO for residential tenancies upstairs. Thank you.
All right. So Mike is not here this evening, unfortunately, to express his opinion and whatnot. But I mean, the bottom line is the non-conforming residential use over commercial use lapsed for over a year. Therefore, is not permitted. So how do you address that?
I'm sorry, would you repeat that?
The non-conforming residential use over commercial use lapsed for over a year.
You mean in 2017 when the CO was issued for the commercial use?
Yeah, that's a few years, correct?
It was a ministerial thing that said that he can retain his office. I don't see that in any way confronts or conflicts with the residential CO from 1957.
Okay. That's going to be up to the board to determine, but I'll open
And
up.
if I might, the fact that there was a CO first and then a second one, the case law says they don't necessarily invalidate the first. They can live harmoniously. That right to again, the CO is limited, the right to retain an office was made for a very singular purpose. It was made to get the CO. But the residential part, in my opinion, wasn't changed by that CO. And that the law says that you have to look at the totality to see if the residential CO in this case was somehow invalidated.
All right, I'll open it up to the board
So,
for
Bill,
questions
just,
here.
I want to get it from a timing standpoint. So, when Mike went up there, at that point, it was being used commercially, or was it vacant?
No, it was
or-
vacant at the time, and the apartment was vacant and was full residential, but it had been used commercial, and
Understood.
the owner at the time thought she'd had a better chance of selling it if there were a right to retain the office.
So it was the owner that pushed then for the CO?
It was the owner that had to get the building inspector up there, and in order to clear the violation, he said that they had the right to retain the office.
Okay.
Bill,
No,
do you-
I
do you have
just
a-
wanted to get the timing of it, that was all.
2017, right before my client purchased.
Do you have a copy of these COs
Yes,
with you tonight?
I do.
Can we take a look?
Yeah, it might take me a minute, my files, but I can get them for you.
Yeah, we're looking in the file to see if they're in the file here too, and, you know, see.
Would they be in the main file?
That's what we're looking at.
Oh, so he's looking at- okay.
Rose?
I'll dig, I definitely have them, and I'll answer any other questions you have while I'm looking.
Rose, any questions?
Yeah, it looks like you have the 2 vacant units plus the applicant has one. Is the residential considered one of those vacant units?
No.
So there's another unit.
My client has a unit,
Right.
one of the 6. There's 2 vacant units,
Correct?
so that's 3, and there's three active tenants. Correct.
And 3 active tenants, because it has here massage therapist, psychologist, contractor, service, and attorney.
One tenant has 2 apartments, 2 offices.
Two people in one office.
Bring that up.
So in addition to these that are listed, there's still the apartment slash whatever this is going to wind up being.
There's 2 vacant apartments. and-
No.
Offices.
I'm sorry, 2
office-
vacant
Two vacant offices,
yeah.
plus whatever is upstairs, whatever we want to call upstairs.
Yes.
Yeah.
So you'll have basically 3 vacant units. So I would think that if you have,
No, we have the upstairs rented to,
it's rented, but the income is not listed here,
it's not.
well, then that would affect our income statement,
Well,
correct?
what we're trying to put to you is that the money generated is far short because we can't rent those other commercial units.
But
If we don't have the residential income, we are at a big loss. We are getting the residential income, but if you don't find for us, that residential income puts us way under threshold.
What is the residential income right now?
20, off the top of my head, 20 something, 2,100, 2,200.
Say 2,100. Okay, so if it's a residence, it's 2,100. If it's an office plus the 2 vacant units plus your unit, you're really not operating at a loss at all. It
Well,
doesn't
if
look
I
like
had-
you're
if
you're
I-
running at a
Well,
2,000.
we can't, the whole thing is we can't get the tenants that want to take the residents upstairs.
What about the other 2 units, the 2 vacant units on the first floor?
So
There have
There's-
been, Joe told me there have been completed,
Yeah.
concentrated
We've had
efforts to get that.
many people come look and,
And you
not having
can't
any
rent
luck.
those 2
No.
vacant ones downstairs?
yeah, both downstairs. Yep.
And you have a letter from one prospective tenant who said, with the parking the way it is, I couldn't go there, especially if you were going to make the upstairs a rental commercially as well.
So right now, you're already full by just having 4 units. 2 are doubled up.
If you don't
already
find,
have
if
too
you
many.
don't find for us with interpretation we're going to lose any income potential on that upstairs. There is no one that's going to invest in that with the parking lot being what it is. There's no way. It's, the residential helps with the parking because they leave
I
in the morning.
understand.
Okay.
But the 2 vacant ones certainly can draw in some kind of income.
We probably would get those tenants if we could get assurance that the upstairs is not going to be rented commercially.
So you think that's what's holding those 2 vacant units?
According to Joseph, who is the managing
Well,
member.
I know like I said, the parking situation is, I mean, crazy there. Like, I can't even get my car in there during the week. So when people come there, the tenants will come there to, well, somebody looking for the office, and it scares them away.
So you're already full when you have,
The
When you
parking's full because,
4
yeah,
offices.
so there's therapists, so obviously would say there's 2 therapists, there's a massage therapist. So when they're there, plus their clients are there, yeah, the lot is,
Is
crazy.
full.
Yeah,
and then you have the psychologist, the contractor, the
Yep.
attorney, and you.
yeah,
So you're already maxed out without the other 2 units and without,
yes, that's the
you
problem with the other
Maxed out
units.
parking.
you're maxed out parking anyway.
Oh, yeah.
Do you have the ability or the property to expand the parking?
No, there's not actually, no, because right behind us, there's, it's commercial, there's, everybody has big lots right there. So there's no room for anything, actually.
I don't think there was a site plan as part of this.
And then with the snow, it's obviously even worse.
I mean, do you meet code for parking right now?
No, we're predated. We don't have site plan approval. This is an existing, pre-existing.
He's basically saying we would open up Pandora's box if we sent it out, because then he would have to get the variances for parking, among other things. Is that what you're saying, Bill?
Yeah.
Yes,
We'll have to get variances for parking.
parking, side yard, front yard, rear yard, everything. It's a non-conforming, as all of the houses and structures are on Glenida Avenue. They're all built a long, long time ago.
So can you give a use variance on something that's pre-existing, non-conforming
Well,
without the parking? It doesn't even meet the parking criteria.
No, I could get a use variance for the use being residential upstairs, even though it's a permitted use now. The area variances would cover the parking, and I would need a lot of them.
You'd need a lot of them.
Yeah, a lot.
Bill, I'm still doubling back to that. So it's a permitted use. It's because the use lapsed that you now have to
Yeah.
go get the use
Yeah.
variance?
Yeah. The code permits residences, residential apartments in a mixed use. It's clear. It had to be existing, according to Mike, because it stopped for a period of time. We've lost it.
So
Now-
you have to go get it back?
Yeah,
Okay. So that's why the use variance.
yeah.
Okay.
So Bill, this original CO doesn't discern whether it's commercial or
I
residential.
have it, John. I'll get it to you. It says residential apartment. I'll have to.
All right, because this is not,
That's the second C.
this is dated November 1957, but
Yeah,
it's-
but there's an elaboration and there's a CO that says residential apartment.
Greg, would this be a use it or lose it after a year?
What transpired here is there was a legal non-conforming use of residential over commercial. The way your code reads is that's permitted if it was in existence as of 1966. The building inspector's interpretation is, never mind the COs, the physical use of residential over commercial lapsed for 1 year, then it's gone. That's the interpretation. That's what he's looking for relief from.
So he could lose
Regardless of what the
everything.
COs say, okay, whether you agree with the argument or you think that the one CO invalidates the prior. The cessation of the use of residence over commercial, it was only permitted because it existed prior to 1966. When that stops for 1 year, the physical use, then the use is lost.
I disagree.
Okay? Well, that's what the code says.
No, it's not a pre-existing non-conforming use. It's a
It's
use that's
legal
been-
non-conforming.
It's a use that's been validated by a CO. That's not pre-existing non-conforming. There's no cessation when a CO a CO'd residential use stops being used for a year or 2 years, that doesn't stop, it's still got a CO. It's not a
Oh,
non-conforming
no,
use.
if it's no longer permitted in the code, then it's not, and it's no longer permitted in the code
No,
unless
no.
it existed before that.
There's a CO for a residence and a CO for an office downstairs.
Correct.
1957. That goes on forever, regardless of whether it stops or doesn't stop. If it's a non-conforming predated use, that means it doesn't have a CO.
No, it's
think
it's
so.
not a pre-existing non-conforming
It's
use.
not.
It's a legal non-conforming. The CO makes it legal, and the code zoned that out if it was after a certain date. And that's the way, that's the position that the building inspector took, and it's a reasonable position on the reading of the code. So you can listen to the arguments and make the determination on the interpretation. You can hear the use variance,
My-
but that's the interpretation that Mike
My-
made, and I
Greg,
agree with it.
My comment to that is, it has legal validity as long as there is a CO, no matter how old the CO is, or no matter what transpires in that zone during that time.
I think that the code zones it out.
Where?
Right.
Where?
It's only permitted in the code if it existed prior to 1966, which it clearly did. Okay, but once it's gone,
It's not gone because it has a CO. I disagree with you.
I think that's semantics. I don't want to get into whether
It's not
the second CO invalidates the first. The physical use is the question. Okay, that's what you have to determine.
All right, Julie, any questions? John?
No, I read the affidavit and understand the history and the background. No questions.
No question. Bill? Okay. Is there any input from the public on this application? Going once, going twice. Okay. I'll look for a motion to close the public hearing.
Motion to close.
Do I have a second? All in favor?
Aye.
Okay, thank you, guys.
Thank you very much.
Thank you.
Thank you, Ken.
Bill, do you want to take your copies? All right, application number 3 this evening is Guy Zelli for a variation of section 156-15, seeking permission to retain an existing deck. Property is located at 85 Entrance Way, Hopac, New York, tax map 74.43-1-25. Good evening, folks.
Good evening. Brian Stone for Mr. and Mrs. Zelli, the applicants here. I'm going to use my Maryland address since I'm under contract to sell my White Plains office, which is 21509 Island.
I'm sorry, your counsel?
Yes,
Okay.
that's why I said for Mr. and Mrs. Zelli.
Oh, okay.
21509 Island Club Road in Tillman, Maryland. If I may, the Zellis bought this property back in 2000.
Before you go further, if they're going to be speaking, I have to swear them in.
Yes, they will.
So I'm assuming, you state your name and address for the record, please.
Guy T. Zelli, 22 Murradon Road, Mayapack, New York.
And your wife, I presume?
Nicole Zelli, 22 Maradon Road, Mayapack, New York.
All right, raise your right hands. Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
All right, thank you. Proceed, I'm sorry.
Zelli's moved into the house that they bought in 2002. In 2004. In 1996, there was a application by the prior owner for a variance on the side, which is the subject of this application, the south side of their property. That variance was granted. It included work for a mudroom and a deck. And so when they moved into that property, they were under the assumption, based upon a survey back in 1972, I believe it was, and that variance, that they were good. Well, it turns out the survey was not accurate, and it turns out as well that there must have been some additional decking put on between 1996, when the variance was granted, and 2004, when they bought the property. They bought the property with the existing deck, just as it is now. As it turned out, the owner of the property to their south, to their south, Ms. Hickey, who bought her property in 2002, commenced an action in 2017 through her attorney, John Malloy, and I mention that because they're both here today and have appeared against and spoke against prior applications on the north side, not where their property is, but on the south side is what we're dealing with now. That action involved counterclaims. There was involvement of different surveys that had different indications, and there was also adverse possession claims in case the Zellies were incorrect, as it turned out they were. And there was very intense litigation over it and intense negotiation. And with the assistance of Judge Zugerby, the parties reached a very specific overall resolution of that litigation. And that was that an easement would be granted and a payment of money being made. That easement was in perpetuity. It wasn't for the life of my clients or 100 years. It was in perpetuity that easement was granted. And I think it's very telling what Mr. Malloy said in the presence of Ms. Hickey at the time settlement was reached. And I quote, Mr. Malloy said, "For the record, I have no doubt that these neighbors and their attorneys will act in good faith." Well, it took more than a year for that easement to actually be signed by Ms. Hickey. There was one delay after another in conferences and calls and emails, and the court was involved, and finally that easement was signed in this case settled in 2018. In the summer of 2019, the easement was granted and it's been filed. Well, after the filing of the easement, these people who were acting in good faith decided to make a complaint that there's a violation because the deck extends onto their property. Of course it extends onto the property. Otherwise, there wouldn't be a need for an easement.
And the deck existed there for how long?
Before 2004, when my client bought the property, and before Ms. Hickey bought her property
So
in
it wasn't
2002.
built, it was existing?
It was built before, that. We don't know exactly when because we weren't there.
Understood.
But we surmise it was built between 96 and 2002 when Ms. Hickey moved in there. All right? No problems for over 15 years. In 2017, the action is commenced, counterclaims, intense litigation, and an overall settlement. And I would emphasize, at the time of the settlement, not only did Ms. Hickey take a very active role in it, but it ended up being so ordered by Judge Zugerby, much like a subdivision by partition in an order. This is what the judge said. This is the easement. This is what's going to happen. And now we have the complaint that there's a violation of the setback. I don't want to get into the legalities of it because we have an order, but it seems to me if there are two people in this world who don't have any basis to complain, it's the two people who negotiated the settlement and granted the easement. If they felt otherwise, they never should have entered into that signed, sealed, notarized, and so ordered settlement and easement. It's not.
We're speaking of this section of this deck. What, is it the whole deck? Steps?
No,
No.
it's a section above that. So that would be the section where you'd be standing on looking down to take that picture.
That is along the side, but before you reach those steps from the front, you have the deck that's the subject of this application.
This piece?
Yes, sir, yes.
And is that your only means to get into your house currently?
That deck,
Is through that deck, or if that were to be removed?
so that's on the area that's in the easement that we're talking about, and that deck is a walkway that goes the whole span of the front of the house.
Okay, understood, but if a portion of that were to be removed to only maintain access to the stairwell, that could be removed if need be.
I suppose.
Yeah, I mean, there'd be a cost involved, I'm sure, to make it safe and what have you, but, okay, just checking the potential there. I'm sorry, I need to cut you
I
off.
only had one final point. This is a little bit unusual. Because it extends onto the Hickey property, the neighbor's property, we had requested that they join in the...
Are you saying beyond the easement? I'm sorry.
Yes, the
So
easement...
it's within the easement, but it encroaches on their property beyond the easement?
Well, no. Let me say it differently. The only reason you need an easement is because the deck extends over the property line. If it didn't extend over the property line, we wouldn't need the easement. all right?
I got that, but what's the language in the easement terms? Is it restricted to just that portion of the deck that ends there and that's it?
Yes, there's a meets and bounds description, and it
Right.
covers the existing deck as it was back when my clients bought their home. My point, though, is that it could be argued that even with a zero variance on our side of the boundary line, there's a violation by Ms. Hickey for the deck that she granted the easement to.
Okay.
And so I had suggested to Mr. Malloy that he join in the application so that her property would not be in violation. She can't remove the deck. She has no authority to remove the deck. She gave an easement to it. So it really would become very complicated if that was not also granted. But Ms. Hickey chose not to make that application. But since we have an interest in the land, Ms. Hickey's land, that's the subject of the easement, we have standing to make the application for both sides of the property line. It's not much, but it's a would be a variance. And so what we're asking for is a zero setback on both sides of that boundary line, because otherwise Ms. Hickey would be in a difficult position, not being able to take down a deck that would be in otherwise violation.
Okay. That's all you got? All right, Phil.
No questions.
John Stark. Any questions?
Yeah, just looking at your survey here, your actual property line. Have you ever looked at, excuse me, just keeping this deck in your property line? It's very doable. Have you looked at that? Had an estimate, a contractor to have the stairs just stay on your property line? Have you ever looked at that?
Well, I don't think the stairs are an issue here. The stairs, I believe, were approved in the 96 variance. It's just the portion that extends to the south of the stairs, to the
Right.
side of the stairs.
There's 3.2 feet over right at the stairs, right?
And then there'd be no reason for an easement.
No.
There would be no easement, there would be no reason for an easement. What we did is we had a claim to that property. We claimed it as ours, both as pursuant to an old survey and pursuant to adverse possession, and the matter was settled. It was settled with an easement. So there's really no reason now to take down that, except for the fact that we need to have the variance.
So you're just looking for the 10-foot variance?
It's not even 10 foot, but
It's
we
not
need the
10
variance
feet?
to the existing, we need the variance to the existing structure, so and that's why it's a zero setback.
Right.
So this is just to bring it into conformity after the fact, after the easement, is that what you're saying?
I'm sorry.
It's just to bring it into conformity after the easement.
It's to have this conform with the existing structures and the order and the easement conform to the town law and town code. That's all we're looking to do, is legalize it. You're absolutely right.
Sorry, Jonathan.
I have no further questions, John.
No questions, I'm sorry. Thank you.
Are you suggesting that everything's in order and this is just the way to complete the file? Is that what you're saying?
Yes.
So, the other neighbor is in full agreement because she signed this easement?
Well, we believe that she is obligated to fulfill the terms set forth in the easement, which is you have the right to your deck, and even though it encroaches onto her property. I'm sure we're going to hear something other than that today.
Sure.
But, and what I'm trying to avoid is to have a situation where we have a recorded document, an easement, a so ordered stipulation that gives my clients the right to use that deck, even though it extends upon the neighbor's property, right? And then have a situation where the town says, no, we're not going to give a variance. Now, who's right? Is the judge right? Is the easement right? Or is it the code right? So the way to avoid that confusion is to have a variance, which, by the way, is not prejudicial to anybody because it's pre-existing. This was not something that was done by my clients. It was pre-existing. And the person complaining about it is the person who has agreed to it by way of the easement.
And how far into her property is it?
I think at the most, that deck extends about 3 feet. It's on the,
4.67 feet over at the
There.
eastern edge. That's the furthest, starts at 3.2 feet.
are you talking about?
That's the
deck?
other side of the property.
Yeah,
The deck in question extends, according to the survey, 3.2 feet over the property line.
Yeah, I don't think there's a need for the setback requirement on the stairway.
okay. There's also, I guess, an old retaining wall down on the eastern portion of the property. That hangs over, too.
Right.
Stockade fence.
And there was fencing that was moved. As part of this, there was fencing that was actually moved because,
retaining wall.
to bring it over. So,
Counsel, do you have the signed order from the judge?
yes, I do.
Can I see that? No, that's
It's
just
the,
easement.
it's the transcript of the proceedings, if I may hand it up.
Yeah, please.
So this area where the railing is the 3.5 feet that we're talking about? If I'm looking at this picture, I see,
Right at the beginning.
where's the mask?
Yes.
So you wouldn't want to just cut it short, that little bit?
Well, then we wouldn't have any need for an easement.
We
have
went
the
through
easement.
a multi-year process to get an easement
And
and
we-
all the trials and
And
tribulations
we
of
would have been
that.
better off just staying with the adverse possession claim.
But it's just that little portion.
That's the little portion. This is not, yes.
It just seems that,
Not obtrusive.
no offense, but attorneys are very expensive, so you're going through a lot of expense for 3 feet.
You're absolutely right. It's something that could have been done. But
Good for
I want you to
lawyers, it's
understand,
good for America,
At the time,
remember.
we relied on a different, but we relied upon a different survey. And the 1972 survey didn't show a violation.
A 1972
A survey, that's when my clients bought it, that's the survey that they had. And it wasn't picked up in the inspection by the title company. If you want, you could hold that. I
can't read it, so. All right, any more input from the board, questions? All right, at this point, I'll open it up to the public without further ado.
we're just going to sign it.
Ding, ding.
You don't need to sign that. That's only if anyone from the public wants to come up and speak. That's not listed on the agenda.
Good evening. My name is John Malloy. I was the lawyer for Ms. Hickey at this case in Supreme Court. Ms. Hickey is a single parent. She was living next door for a long time next to the Zellies, and the deck was bothering her. But then there was more construction. There were fences put up. There was a wall put up all the way at the rear of her property, and she finally had enough, and we sued for trespass for all of the different encroachments along the property line, from the curb, including the driveway, all along the side of the house with the deck, and then back with the stairs encroached on the Hickey property, and then there was a retaining wall at the rear of the Zellies property, which was too long, and that even encroached into the Hickey property. So we sued, we went to court, we had discovery, we had depositions. We came for the day of the trial, and Judge Zugaby, as you may know, Supreme Court judges try and settle cases. They don't necessarily like to try cases. Judge Zugaby asked me what the demand was, and I don't remember exactly, but it was probably something like $1 million. And he said, what can we do to settle the case? I said, we can't settle it. I have to try the case. And eventually, after browbeating by the judge for a while, the offer was made by the Zellies weren't there. The Zellies couldn't try that case that day because they weren't in court. So they offered $10,000, and they asked for an easement. Now, what the easement did, we took the easement all the way from the front of the property to the rear of the property. We had them remove the section of the retaining wall at the back of the Zelli property. They had to remove the section that encroached. Parts of the fence were allowed to stay, parts of the fence were moved so back onto their property. But please don't confuse easement with setback. Ms. Hickey asked me, would the easement affect the setback requirements of the town for the deck? And I said, absolutely no. If neighbors could create easements without the zoning board, we wouldn't need a zoning board to offer variances, to authorize variances. So in this case, we gave an easement, which is what the Zellies asked for. We accepted $10,000 to settle the trespass case. It took a while to get the easement because we had to wait for the surveyor. The surveyor was Mr. Odell. He had to do an exact meets and bounds description of the entire property line and what was excess, what was over onto our onto Hickey's property. The deck is 3 feet onto Ms. Hickey's property. What's the setback requirement? 10 feet? So it's 13 feet in excess of what's permitted. We knew that when we granted the variance, the easement. The easement doesn't affect a variance. You can have an easement and still require a variance. And in this case, that's what exists. They have an easement. We can't sue them for trespass, but they don't have a variance. And so the town can require them to remove the deck that's within the setback area. And that's as simple as that.
So we're just cleaning up the file.
Sorry?
We're cleaning up the file. If you agree to it, they agree to it, as long as we agree that you can have a 0 setback because of this situation.
Sure.
We're basically just cleaning up the file.
So Mr. Stone called me, he said that Ms. Hickey had to apply for a variance because she has a deck within her setback area. I said, no, we're not looking for a variance for the deck within the setback area on the Hickey property. She doesn't want a variance for that. She's not applied for a variance for that. And I guess the remedy would be that she has to have that section of the deck removed that's within her property line. And so we would go along with that. Mr. Zelli can require a setback variance up to the property line. So if you want to confuse the easement with the setback is measured to the property line. The fact of the easement doesn't extend or diminish the setback requirement. So you have 10 feet from the boundary line. If there's a 20-foot easement that the neighbor gives next door, does that mean that a person can build a deck 10 feet over the line? It does not. You have a requirement that concerns boundary lines only. And this deck has to be 10 feet before the Zelli boundary line, and it's actually 3 feet over. So what he needs is a negative 13-foot variance.
No, he needs
he needs
a
a 0.
10-foot. He needs a 0. That's what he needs, a 0, up to the property line, that's it.
If he gets a
You
0
said it.
variance, then the deck that's on the Hickey property can be taken down.
That's your fight someplace else. That's not a fight here.
That's with,
That would just happen.
That's not a fight here. And I don't want to get into that fight.
Okay.
that's within the parameters of the easement, so.
You guys can fight that out.
My doctor told me to avoid controversy, so
Me too. We must go to the same guy.
Dr. Vinny Bumbach. All right, anybody else? Oh, you said, John?
If you have any questions about that day in court, I mean, as far as Judge Zuckerby was concerned, he did a great job. He settled the case. These people have to live next door to each other. So we wanted to be cooperative, but we're not looking to be stupid.
John, was that deck there before she bought the house? Was that deck there before she bought the house, John?
She doesn't know. We went over that a long time.
I know.
The fact of the matter is that the trespass is every day. There's no statute of limitations.
Speak into the mic, John.
If it's a continuing trespass.
Understood, but you settled that. That's settled matter now. So now we're talking about an easement that was granted, and I don't think they would have accepted the easement if they didn't think they could keep the deck either. I mean, we're talking intent here now, John.
So Ms. Hickey had a lawyer that day, And I have some experience with easements and setbacks, and I advise her that if she granted the easement, it would have no impact on the Zelli's need for a variance.
Correct, and that's what
That was-
we're here
That was
for.
the advice that she went with, and that's why she granted the easement. Am I wrong? I don't think so.
No, John, but there's an assumption there. You wouldn't have settled unless that deck was going to stay. They wouldn't have settled. They would have taken you all the way. Come on.
All right.
We're splitting hairs here is my point.
Well, I don't know that we're splitting hairs, just look at the deck. But the
Okay.
easement went from the curb all the way to the back. It was the full depth of the property. I don't remember offhand, but it has to be 75 feet.
Understood.
And we're talking about 1 3-foot section. Maybe, yeah, about 3.
Okay.
Questions? No?
Thanks, John.
Anybody else wish to be heard on this application? State your name and address for the record, please. And, hey, Dominic, when you get a chance, can you come in and try to fix this mic that's flopping in the breeze?
There's a little blue pill.
Just, yeah, use the other, name and address. You can use that one, it's a little more rigid.
Christine Hickey, 81 Entranceway, Mayapack, New York.
Right hand, please. Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
Thank you.
Good evening. Spring 2017, I notified Mr. Guy Tomaselli that he built multiple structures on my property. He asked me when I needed them removed. I told him that I needed them removed as soon as possible because I was trying to sell the house. Within 48 hours, I received a letter from his lawyer, Brian Stone, saying that I would not be able to afford to fight him in court, that I should forget about the encroachments along my 100-foot northern property line and live peacefully with my neighbors, the Zellies. I'm not sure how many of you know Irish land history or the intrinsic strength that a single woman needs to buy her own house and raise 3 children alone, but clearly Mr. Stone underestimated me. I immediately contacted the building department and was told that they could not help. They advised me to call a lawyer. I called my partner on the executive board of the St. Patrick's Day Parade Committee, John Malloy, who agreed to represent me. This has been a long, difficult 4 years. While this case has been playing out in the courts and building department, I was forced to watch the Zellies continue to trespass on my property. They rushed to add materials to unfinished projects to make it more difficult for the courts to rule against them. They joined with another neighbor, Mr. Ragusa, who placed a shed directly on my northeast property line and then built a wooden retaining wall on my property to protect the shed from dirt falling down from my hill. I guess he was empowered to do so by witnessing the years that the Zellies were allowed to remain on my property. That issue was eventually rectified by this board on September 2019, although it took another solid 12 months before the building department was able to enforce this board's order. April 2019, the Hickey-Zelli case was settled in the Supreme Court of Putnam. The Zellies agreed to remove the most egregious encroachments on my property. They were awarded an easement for their driveway, the property under the deck, the masonry stairs that they built into my beautiful concrete wall, and the landing into their backyard. The Zellies offered $10,000 to settle, and I agreed. I immediately began reclaiming my property by erecting a new fence on my line. The Zellies had their surveyor returned to mark the line again to make sure that I did not encroach on them, which of course I was careful not to do. This deck represents the last piece of this 4+ year case. After the court case was settled, I contacted the building department many times to request that this illegal deck be removed. They asked for my line survey from David Odell, which I sent. John Malloy also went to speak with Mike Carnazza several times on my behalf. No satisfaction or attention was given to my case. I, however, was violated for changing an oval pool to a round pool without a permit by Dennis, the code enforcement officer. He never noticed Mr. Ragusa's shed on my property line 20 feet away or the Zelli deck. When it was brought to his attention by me, Dennis actually said to me, where else can he put that shed on his landscaped lawn? With my persistence, the building department was forced to violate the shed. It was eventually, 1 year later, brought before this board, and he was ordered to move the shed. 12 months later, after ignoring several visits from the building department, he moved the shed and the wooden retaining wall. Of course, I filed the correct application for the pool, paid my $250, and I have a CO for my round pool. The building department did not resolve or move to resolve my issue with this deck. I want to publicly thank my friend and town councilwoman, Susie McDonough, for intervening on my behalf with the building department. I am pretty certain that without her, I would not have made it here tonight. The deck is illegally built, and it encroaches more than 3 feet over my northern property line. It is covering crumbled concrete and other debris, which I have to constantly see from my lawn. The Zellies also ran a drainage pipe from their driveway under this deck, which is draining water and driveway residue onto my property. I am asking the zoning board to deny this application and to order this encroaching deck and garbage removed from my property. A few final points. The Zellies moved out of their house November 2019. It has stood empty for the last 14 months. I want to publicly thank handsome Jack Malloy, Susie McDonough, my family and friends for supporting me during this very difficult process. I want to thank the Putnam County Supreme Court, the Putnam County Zoning Board of Appeals, and the Carmel Building Department. Towards the end of this process, Mike Carnazza became very helpful. He did what he could from his position, and I am grateful for his help. Thank you.
Thank you. Thank you. Anybody else wish to be heard on this application?
These are the pictures of measurements of the height of the illegal deck, the length of the deck, the garbage that's underneath it, and I don't know if you want to see them up close and personal, but this deck, we don't even know if it's safe. We don't even know who built it. And they don't live there anymore. They come by once a day to check the mail. So there's no reason to keep this on my property. Thank you.
Okay, thank you.
Put it on that easel, so they see on the camera.
Anybody else wish to be heard?
Put it on that easel just for a couple minutes.
Any more input from the board? I'll look for a motion to close the public hearing. on
Motion
this
to close.
application. Do I have a second?
Second?
All in favor? Aye. All right, thank you. Let's see, number 4 this evening is CRM Properties Management seeking a use variance 156-48A to allow construction of a 2-car garage on the lot with multifamily use in an R120 zone. The property is located at 689-690 Route 6N, Mahopac, New York. Tax map 75.11-1-10.
Good evening. Martin Stacekel from Architectural Visions. I live at 34 Linda Lane in Bethel, Connecticut. I'm representing Mr. Kosovic from CRM Properties. We are seeking
Hold on, sir.
Oh, okay.
Raise your right hand.
Sure.
Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
Thank you.
Okay.
Proceed.
All right. We are seeking a variance for a use, section 156-48A, where the section says that no building which houses a non-conforming use. So this property is considered non-conforming, and there's an existing 2-car garage on that we would like to extend and add additional 2 cars to it. So from this section, it says that no existing non-conforming use shall be structurally altered or enlarged, which is what we're looking for the variance for.
Okay, so this, you're extending the existing,
Garage towards the back.
okay.
This is a use variance? Extending the use?
It's a non-conforming use. It's under the non-conforming use in the code.
Or is this like one of the ones around the lake?
Yeah, the Bonnie Law.
It's a use variance.
It's a use variance.
The setback requirements are met, but because it's a non-conforming use, the property itself, the variance for the use.
expand the use.
Okay. So, all the following must be met. Number one, capable of earning a reasonable return. Return if used for any allowable uses. Dollar amounts must be shown. The property is affected by unique or at least highly uncommon circumstances. Number three, will not alter the essential character of the neighborhood. And four, not self-created. So I'll remind the board to, think of that as they're thinking of any questions. John, any questions on this?
The existing structure, garage, are you going to replace that garage too, as far as the roof?
The roof will be replaced.
The block? I took a ride out there, and it looks really dilapidated. It's falling down.
I don't believe the block was falling down. The
Block was
roof-
okay.
The roof, the overhang on the roof is falling down.
Windows?
Yeah,
windows.
the fascia and the gutter in the back was
Yeah, the
falling
overhang
off.
on the roof. Yeah, that will be replaced and new roof on the new addition.
But you're keeping the same roof line?
Yes. Yeah, we're not changing the height of it.
Why are you doing it?
To give them additional parking spaces for his tenants. And storage.
Okay.
No further questions.
Phil, any? No questions. Questions? Julie?
Is there any plumbing or electric in the garage?
Is there any what?
Plumbing or electric?
Plumbing or electric?
No, there's electricity, there's lights, but no plumbing.
Okay. And it's solely going to be for parking cars or storage?
Storage and parking.
Okay, Rose?
Given it's a use variance, it has to comply with all four criteria. You haven't come in with any financials to show that this property is incapable of a reasonable return. And it seems like it's self-created. The Bonnie Lock has been around for how many years? And they've done without a garage for how many years? When was the Bonnie Lock built?
I do.
Yes, state your name and address for the
Andrew
record.
Kokovic, 17 Bonniewood Drive, Mayapack.
Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
Go ahead.
I'm sorry.
When was it built?
Early 1900s.
So it predates code.
1908 or something like that.
And how long was the garage that's existing there now?
Uh,
Was that part of the original property?
It's probably original, yeah.
Isn't it cinder block?
Cinder block back then?
Yeah.
Cars back then.
Beats me, I don't know.
They made it with real cinders.
It was a stable.
I purchased in 2014, so I don't know. And as far as the financial, I haven't made a penny on the property because it was dilapidated. And I've been putting everything into it and just need a little extra space for my lawnmower, my equipment, and some parking space.
How many units do you have?
You got a total of 14.
14 units?
Yes.
Okay. And what's the acreage?
It's just under 2. It's
Under 2.
1.97, I believe.
So, I don't know how a garage could generate income for you.
It's not so much generating income. Well, yeah, I could probably maybe park a couple of cars in there, but it's also for my lawnmower, my trailer, my tractor and stuff like that.
Well, it seems that since 1908, or whatever the year is, it's done fine without
Well,
this.
they've hired outside contractors. I do it myself, so that's the only way I could make ends meet.
14 units on less than 2 acres. I think it's fairly well covered. There's a lot of, the acreage has a lot of buildings on it. What is it, 4 buildings on 2 acres?
3 buildings.
There's the 3 housing
Right,
units
with
and the
with
garage.
the garage, right.
4
We're just
structures.
We're just duplicating the existing garage. There's two-car garage, we're just going to make it 4 now, an additional 2.
There going to be a second floor on it?
No.
No.
Just extend to the back.
The bottom line is you're expanding the use. So
Correct.
you have to meet, you have to prove to us a financial burden for the reason why you want to make this expansion. You have to have tax info, rental income info. You have to show us this to
I
prove
wish I
it.
knew, I would have brought it with me.
Yeah, I think we're gonna have to hold it over.
We can hold it.
Yeah.
Because I could bring you my last 5 years of tax returns, there's losses on
Yeah.
the property.
So-
I mean,
If that's the only thing that you need, I'd be happy
So
to
if
share.
you're asking to, we could put it over a month, and then we could have you come back with that information, because that's what you need.
yeah.
Okay?
Okay,
All right.
All right.
Thank
So-
you.
thank you.
Thank you.
Just hold it.
Yeah, is there any input from the public on this application? All right, let me close the public hearing, and we can,
Hold it.
yeah, well, all right. I'll look for a motion to hold this application
Motion to
over.
hold it over.
Second.
All in favor?
Aye.
Okay,
Yeah, because they have-
that's fine. We can worry about that later.
Joe, turn up the heat over here, would you? Turn up the heat over here.
All right, application number 5,
Mr. Chairman, can I just say one thing before?
Q Yang, for variation of 156, seeking permission to,
To close the hearing, can I just say one thing before you go on?
I asked for public input, you didn't respond, so I closed it, we closed it already.
Okay.
We close.
Sorry, Joel. I'm sorry, Mr. Yang, variation of section 156, seeking permission to replace a shed in the same location.
Joel, just hold it.
Property is located at 4 Green Acres Lane, Mahopac, New York, tax map 74.11-1-19. Good evening, gentlemen. Are you both going to be speaking?
I'm like kind of like translating for my dad because he doesn't speak a
Okay.
lot of English.
You move to this mic, and you can stay at that mic. State your names and address for the record, please.
Isaac Yang, 4 Green Acres, Manhattan.
And,
Yeah, for Green, I said name, you may help it.
okay, raise your right hands. Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
And you agree to translate from what language to what language, sir?
My dad speaks Mandarin.
All right, so you agree to translate from Mandarin to English and English to Mandarin to the best of your ability? Thank you.
Okay, so the shed is there. How long has the shed been on the property?
多久而已？
家，大概6年左右，6年可能，6 years。
It was there before we bought it, and
Speak it to the microphone.
it was there before
You
we
can turn it
bought
up.
it, and we've been living there for like 6 years.
Okay, and it looks like it's fairly old. I went out there with John the other day, and we had some confusion as to where this was, but it didn't look like the footprint of the house was the same as what was there. But I guess we finally realized it's that square white one that looks like it's pretty old. It's been,
The one that with one wall standing.
Oh, with the wall standing is the one. It was like a brick block.
Wooden block.
One end is block. Yeah, so that's different.
Didn't you take a picture, John?
I did. I took a picture of the shed, which I thought was your shed. This white shed, but that's not it.
So this was more along, as the road comes in, the house is on your left. There's a white shed back further, but there was another half-wall shed almost on the driveway going to the next house.
Yes.
Yes, that's the shed.
Okay, it didn't really appear accurate on the site plan, so that was kind of confusing, but I think we are clear now. So, I mean, you're looking for pretty much a 50%, give or take, variance, but that shed, or lack of, half a wall, whatever you want to call it, has been there for that long, even prior to you purchasing the property?
Oh, no, it was like last year around March, there was like a storm, a tree crashed into it, that's when it broke.
But it was there when you bought the property 6 years ago?
Yes, it was already there.
Okay, so I guess it never got picked up on a title search. A title search would be what a title company, when you exchange properties, they check to make sure there's no
Unless you pay bought it in
issues
cash.
or.
If you bought it in cash, you don't go through title, do you?
Yeah, true.
You do.
All right, so that's the reason why it's coming up. So there's no other property that you can buy to bring it into conformance, right? You're landlocked, there's no other property that you can buy around you,
Oh, no other problem.
okay? There's a footing there already for it, I think, right, if I remember? So it'd be expensive to relocate that footing, correct?
Yes.
Okay.
It's a good spot for it.
Yeah. All right, any questions from the board?
I have a question, just, is that your shed too, though, that white one?
The white one, yes, but we
Is
don't.
that on your property?
Yes.
It is. You know, there's the drawing for your layout, your site plan, your tax map, I don't think it's accurate of your house, Green Acres, Secor Road looks right. It just doesn't look right, okay? Because where that shed is located, I don't know if it's even on your property. You know, I don't even know. It doesn't, didn't really add up too well, but that's something else. But you want to knock this whole structure down that's left, correct? Whatever's left falls down?
We want to replace it with a shed, because it was a shed before, it was just a wall right now.
So you're going to put a prefab there?
Right.
It's a no-brainer.
This says Walnut Drive on the survey.
Walnut Drive, it says,
Yeah, on the survey,
it's
Secor.
Green Acres,
but it says
the front
on
of
the
the house.
survey.
Secor Road is the road, that you turn the main road, primary road.
I don't see Green Acres Road
No,
on
that
this
may be where he
survey.
lives, that may be a rental property, Rose. Remember that, the name of the property owner and the address doesn't necessarily have to correspond to where
Well,
the
they're the
property
same, 4 Green Acre Lane,
4 Green Acres Lane.
mailing and address.
Oh, no, that was the directions, you're right, why does the survey say that?
Survey says Walnut Drive.
Yeah,
I don't
that's
think it's
weird.
the right survey.
Walnut Drive, no, that's there.
Do you guys have the same
Drive,
survey
that's
that was
before
submitted?
him. Green
This-
Acres is over here, they don't even see it.
Does it say it?
It was probably established after this house,
1976.
but it's over here. What's that?
There's one house after this.
Yes,
On Green Lane.
right.
Green
Not
Acre.
that it's not showing you.
It's not showing you that house.
Well, this looks like it's 4 lots,
Four lots.
but I'm not sure if it's the same. Yeah.
What's the white one there? Pretty,
I'm looking for a date
All
on
right,
that.
so,
But I'm just saying,
get you drawn.
that is your shed, the white one?
The white one was also there when we bought it.
Yeah, so that's your shed on your property, right?
Yes.
You probably need a variance for that too, then. Just, John, it was on the property line there.
I know, but, Mike reviews these applications, so when he checks
would've
it, he
flagged
signs off on it, he would have found it as
Yeah.
such. So right now, what's in front of us is the shed that, I don't know if anyone else got out there to see it,
No, I didn't
but
get a chance.
do you guys have any pictures?
Yeah, I got a picture.
My dad has a picture.
I'd like to see a
The
picture.
existing, right?
Yeah.
Let me just see that, please. It's all right.
That whole thing on the right.
Oh, that's when the tree fell down on it. Okay. Good. Yeah? Yeah. Yeah, it was right there, walking around. Nice place.
Well, you saw it, so.
I'm satisfied. Okay, we saw the one wall, you're gonna remove that and then install the shed prefab there. Doesn't look right.
Okay. So
No
it's
further
it's the
questions,
shed that
John.
we saw. You're suffering a burden here too from the unfortunate fact that a tree killed your shed, so I think we need to be lenient to a certain degree here. All right, any other questions from the board members?
No further. Thank you.
Any input from the public on this application? I'll look for a motion to close the public hearing.
Motion to close.
Do I have a second?
Second.
All in favor?
Aye.
Aye.
Thank you.
Thank you.
Thank you.
All right, number 6, Dave Hovsplin for variation section 156-15, seeking permission to expand and renovate a second-floor bathroom. Property is located at 740 Croton Falls Road, Carmel, New York, tax map 77.18-1-25.1. Good evening.
You had a typo on that number. It's .6, actually.
We can't hear this. All right.
And Bill Schilling's going to come back to talk for another hour.
All right,
on my
state your
behalf.
name and address for the record.
Dave Hosepian, 740 Croton Falls Road.
Swear to tell the truth, whole truth, nothing but the truth, so help you God.
I do.
Okay. Bring us through what you're looking at.
Hopefully, this is pretty simple. We have a small bathroom on our second floor. approximately 10 by 3. We're just looking to expand it, going out 5 feet over an existing roof. We're not extending past the footprint of
So
the
you're staying
current
within the
house.
footprint, so
Correct.
the reason why you need to come through here is because you're going up.
Comfort, you need comfort.
Right. There's no other property you could purchase to make it conform.
Right.
Cute house, by the way, different style than what we're used to seeing. You talk to your neighbors, there's no real neighbors on either side, or
Yeah, the
that side.
closest one, the Brysons, are like 3 football fields over, so.
I've been curious about this for years. The house to the right, what is that digital thing on their roof?
I don't know.
Pattern?
I don't know. That's
All right.
something new, actually. He
All
just
right,
did that.
I'm not going to waste any more time. Board members?
No
any
questions.
No questions, thank you.
No questions?
John, Bill, any input from the public on this
Beautiful
application?
house.
Thank you.
No question.
I'll look for a motion to close the hearing on the
So moved.
application. Do I have a second?
Second.
All in favor?
Aye.
All right, thank you. Number 7, Vince and Anne Marie Serio for variation of section 156-15, seeking permission to construct an addition. Property is 43 Kennard Road, Hopac, New York, tax map 86.14-1-5. Good evening.
Good
Name and
evening.
address for the record, please.
Vinny Serio, 43 Kennard Road, Mahopac.
Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do. I'm looking to build an addition on my home, requesting a variance because I would be going to the left of the home, roughly 20 feet by 30 feet.
All right, this one, I was concerned about, that you spoke to the neighbors on the immediate left? I mean,
Yes, I'm very close with her, and she has no problem with it. She's fully aware of what I'm doing. She was going to come here tonight, but told her not to, just for her own timing.
And the reason for the addition, family's getting
Yeah,
bigger?
it's going to be an in-law suite, yeah, for my mother-in-law.
And would you have, the garage now is going to become part of the house, and this will be the garage? Did I read that right?
No, the garage is going to be existing, it's going to stay there. I'm going to the left. Economically, I would like to do it to the right, but the septic is over there, so it's not cost-effective to have it on the right side.
And you got that pond in the back, right? Is it mostly wet there? When
Pretty
we
wet.
saw the property, yeah.
Yeah, it's not too bad. Actually, ever since they built those homes in the back of Somers, by the golf range,
Yeah.
that diverted a lot of water, so
Oh,
that helped
really?
out tremendously, actually.
That's not usual that you hear.
Yeah, I know.
Development
They
helping.
did a good job.
Yeah.
There's no other property you can purchase to bring it into conformance, correct?
No, there's not.
All right, you said your septic's on the other side. And across the street, there's a new house, right? That's been
Correct.
bought
That-
yet?
Yeah,
Sold?
yeah, that's bought. They moved in, living probably another month, but yeah, it's moving trucks, propane, yeah.
All right, no issue, they had no concerns or issues? Okay.
Nope.
Okay. Board members? Any questions?
You had it marked out pretty well for us to see, so
Yeah, so you had it all roped off, and
I don't know if I'd go 8 feet down for a full basement in that area, but
Yeah, we'll see if I get lucky with it.
is that the plan?
Maybe 6 feet, but with the house already, this is about 5.5 feet, and I don't have a problem with water for 5.5 feet crawl space, so the grade of it, I might get lucky with it.
Okay, well, you won't know until you start digging.
That's it. Maybe I hit oil, I don't know.
No questions, thank you.
All right, any input from the public on this application? I'll look for a motion to close the hearing.
Motion to close.
Do I have a second?
Second.
All in favor?
Aye.
Thank you.
Good luck. Application number 8, Lawrence and Diane Gorlick for variation of section 156-20, seeking permission to build 6-foot fence where 4-foot fence is permitted, and an 8-foot fence where 6-foot fence is permitted. Say that 5 times fast. The property is located at 47 Fenwood Road, Mahopac, New York, tax map 76.18-2-54. Good evening.
Good evening, everybody. Michael Caruso, attorney for Dr. Lawrence Gorlick, Diane Gorlick. Good evening, everyone.
Okay, bring us through it.
All right, so we have an area variance here. My client seeks to construct a fence As you can see on the survey that you have in front of you that's color-coded, the blue section, which is approximately 7.5 feet, running from the front to the rear, is where we're seeking a 6-foot fence where a 4-foot is required. And the vast majority of it, as you see in green, running to the back, is where we're seeking 8, where 6 is required. The application package has some renderings of the fence, which would be proposed by Campanella in a tasteful format and good construction. They're a reputable firm. I'm sure that the installation will be done correctly. So what we're proposing here, we think, is offset as well. If you look at some of the photos I've provided, and forgive me if they're a little far away, I can walk you through them. You can see on the, try to be brief here, you can see on the right side of the photo here that I'm pointing to, this is the Gorelick property. To the left here is 51 Fenwood, their neighbors to the north. The Gorelick property is at a substantially lower grade. So the reason for the variance, I think, we believe we can mitigate the substantiality by the difference in grade between the two properties. Just for clarity, the fence would be constructed here. My clients own this wall. They have enough room. There are certain points where this wall gets awfully close to the property line. They have the ability to pull it back and put the fence in without an issue. So what they want to do is just offset the height of this other structure looking down, put in a nice fence as far back as they can, just for some privacy here. And as you can see here, the property line which has been staked here, please disregard the string, that's not accurate. But the stake here and where my finger is back here is where the actual line is. So my clients would really be putting this to identify the boundary between the properties, get some privacy. As you can see, there's a shed here that's within the setback on the 51 Fenwood property, which is not my client's. But some screening and to offer privacy there. And you can see a little enlargement here of just how close that shed is. And just for reference, on the bottom right here, you can see there's a yardstick that identifies the rock wall that you see here, about midway back on the property. It gets to be about 3 feet tall, and I'm not certain whether the difference in grade is about 3 feet or not. It's probably something a little less, but it's just illustrative, to show you that the variance we're looking for is really offset by the grade and the property above the Gorelicks. So let me just run you through the criterion. I know you've had a long night, so I'll try to be brief. This fence is going to go, by and large, out of street view and directly to the back of the property. My clients don't submit that it'll create any undesirable changes in the neighborhood. There are fences in this neighborhood. I wouldn't say a lot of fencing, but there are fences. We can't obviate the need for the variance because my client's been here for 50 years. They're an 80-something-year-old couple. Dr. Gorelick's a retired dentist. They're quiet people. They've never had an issue in their lives, but they do want a little privacy. So this is not something that can be obviated. They can't relocate their house, and they can't really do much with the grade other than to seek privacy this way. I'd submit to the board that this is an insubstantial variance, both by the arithmetic and by the mitigation. Just the fact that the property above it, which is really the only property in question that would have any major impact from this, if you could call it that, is going to be looking down. And, really any height differential is going to be offset by that difference. We don't believe there's an adverse physical change presented by this. There's nothing that's going to be disturbed other than perhaps pulling a few rocks back and maybe laying in a little bit of topsoil to keep the grade consistent. And outside of that, there's really no self-created hardship. Like I said, my clients have lived here for 50 years. They're quiet people. They like their privacy. And, naturally, the course of development has caused more houses to come in. Nobody's fault, obviously. There's really no way around this to achieve this goal. So, as they say, good fences make good neighbors, and we hope that's true. So.
All right. I mean, a 6-foot fence would do the same thing, in my opinion. I mean, it's what's allowed by code. So I really don't understand why they would want to do this.
Well, it's because of the height differential. If you put a 6-foot fence up, considering the fact that there is a degree of slope here, a 6-foot fence doesn't offer them much privacy. So that's why we're kicking it up.
Where's the Gorelick house compared, I mean, I know we don't have a picture of
It's
it,
to
but
the
where
left.
is it compared to where the fence is?
Well, the Gorelick house, if you were to draw a line, see this house is at a different plane. The Gorelick house is about over here where my finger is, maybe a little bit further forward.
That's taken from the back of the property?
This is taken from the back looking forward towards Fenwood, correct. This is from the front looking back. So again, it's not that, you know, an 8-foot fence is not really something you set out. When you buy a house here and you build a house, you know, the idea is to keep it as minimal as possible. But again, with the difference in height here, which is 3 feet here at least, you know, as it looks, it's a little tough to get any privacy out of 6 feet. So that's why we need a little bit of a bump. So we've tried to keep it as minimal as possible, but we really think that this would achieve the goals of the clients.
All right, you know, I'm worried this is a Pandora's box if this thing gets approved. You know, I'm one person up here, but I don't think it's necessary, in my opinion, based on the facts of what I've seen here and visiting the property. John and I were out there on Sunday. I have a letter here in opposition from Charles and Doris Harmon, residents of 51 Fenwood Road. Dear Chairman Maxwell, the adjoining residents Lawrence and Diane Gorelick of 47 Fenwood Road have submitted an application for variation of section 15620 seeking permission to build a 4-foot fence where permitted to have a 6-foot fence and an 8-foot fence where permitted. We do not oppose the application seeking a 4-foot fence to a 6-foot fence. However, we are opposed to the application for an 8-foot fence, which we feel would adversely affect my family and our property. We are asking that you, in your official capacity as chairman of the zoning board, deny the application for an 8-foot fence. The consensus with my family and neighbors is that an 8-foot fence would make the area look commercialized, possibly reducing our property values and take away from the country setting we all have become accustomed to in Mopac. Additionally, such a large fence would adversely affect the wildlife who use this area as a trail. The area where the Gorlicks plan to put an 8-foot fence is an unmanicured area, wooded area, where perhaps privacy trees may be better suited. We as homeowners have expressed our opinion to the applicants before this matter was brought to the zoning board, which were disregarded by the Gorlicks. Thank you for your consideration in this matter. I think they couldn't be here tonight, that's why they sent this, so that's why I read it. So that's to be taken into consideration. Do you have anything further?
Well, look, you know, the board may be looking at it in isolation, saying, look, an 8-foot fence is large, but again, if you're visiting the site and you see the slope up to the property above, and you noticed, you know, the improvements in the photos here, you know, we feel this is in the best interest of both parties. You know, there has been a bit of friction between the neighbors, leaves being blown, you know, that sort of thing. What we're trying to do is keep a good boundary that both sides, you know, respect, and one that's tastefully done. It's not to say necessarily that the Gorlicks have to have 8 feet the entire way back. One thing for the board to consider would be, for example, there is a difference in grade that is probably a little bit more extreme in the middle of, if you look at the course on the survey, the photo that was taken on the bottom right is approximately midway back. So the board could perhaps consider stepping it down toward the rear of the property if that's an option. But again, we feel this is something that's important to establish the privacy that these parties need. I think there's mutuality to that. And again, if you drive up to the property and you're looking at 47 Fenwood, which is up on a hill, the vast majority of this fence is going to go way back. So it's not going to be up front and close to parties who are driving by, who are neighbors who are looking at it. I think there is a definite mitigation on the visual impact just on the way these properties are configured. But again, that's up for the board.
Okay, again, my opinion, it can be delineated with a 6-foot fence that you don't need a variance for a certain portion of it, but.
How long is the 8-foot section going to, I'm sorry. How long is the 8-foot section going to be?
Well, when you go just from where the green starts on the survey I provided to you, that's approximately 220 feet. It's long. It's a long way.
Thank you.
How many feet?
Approximately 200, I'd say approximately 220, 225.
250, okay.
I think the whole length of that rock wall section is 250 feet or so, but we're not looking to get the fence to cover the all of the rock wall.
So that
It's
rock
probably gonna be a
wall
bit
is on the
shorter.
neighbor's property, not the Garlic's.
The rock wall's entirely on the Gorlick property, with the exception of a de minimis, a very small encroachment at one point, around the
So you want to be
midpoint.
8 feet above the rock wall.
No. The rock wall stands about, as you see right there, it's almost a yardstick tall at times. So we'd be going 8 feet from the bottom of the yardstick up, so it'd be 4 or 5 feet above the rock wall, if you will, at the most extreme, I believe. It's an odd configuration to have that wall there. It's something that has stood there for a very long time, I think since they bought the property in '71. But as you can see over time, it's become a bit of an issue because I think it's skewing the actual boundary line of the property. There was some fill done by the shed in the back in the bottom left on the neighbor's side that was, on the Gorlick property. But again, this is just about keeping the boundary clean and keeping some privacy. And it sounds like a lot, but really, I think when you look at the grade between the properties, it's really not that substantial at all.
Would your clients be interested in the suggestion with the privacy hedge, some green arborvitaes that grow much taller than that and give better privacy and look much better in that kind of neighborhood? That was a beautiful road right here, Fenwood.
Yeah.
Looks like there's a possible vineyard that's up there. Another neighbor has like a vineyard growing there, and it's wide open. Each property runs into each property.
I was going to mention that.
Looks really good.
That the house is
having
on-
an 8-foot-high white vinyl buff tech fence is sort of shocking in that area.
I tend to agree with you. I mean, there are ways to tone that down a bit. If the type of construction of the fence, if the board wants to consider an alternative to white vinyl, something more natural looking, something a little bit less, visually impactful, of course, it's up to the board to consider. But
Put a 6-foot fence up on a rock wall? They can dig around the rock.
well, that wall's pretty substantial. Really what we want to do is try to minimize the amount that we move it, because the neighbors have placed fill up top. We don't want to disturb their property either, and what has now come into existence. So we want to move that as little as possible, I guess, if we're putting that fence in there.
I
for
mean,
both
with the
parties.
exception of the shed, the houses are pretty far apart from the property line, too, so.
It's a little tough to tell from the photos, but I'm going to take the mic with me for a second. But from this point, if you see the vehicle here, where the driveway is and these tall trees are, it's not a far shot to the garages and some windows in the Gorlick property. I couldn't give you an exact on the distance. I'd say, 70, 80 feet, maybe 100 max, but it's closer than you think.
It's pretty significant.
Further than mine.
We were there.
I know.
When
it
was
looked
the
like
other
it was
house
further
built?
than my neighbors. Yeah,
Much
exactly.
closer to that. I
I'm
don't
not
have an issue.
certain. I'm
have
not
a
certain on the
wall.
construction, but I
That's-
believe it's substantially newer.
Substantially newer?
Yeah, Gorlick was 71, and I have old photos, but I think, I couldn't tell you the date of construction of that house, but I think it's a lot newer.
A lot newer.
While people think that 2 feet is not that much, when you back it up to 220 feet of fencing, it becomes substantial at that point.
Understandably.
And not only of fencing, Rose, of stark white
White
vinyl
fencing.
fencing.
Right, and you have
Any color.
and a neighbor
Any
doesn't
color.
want it. Any color, right. And a neighbor doesn't want it.
Well,
It's
look,
very
it's
hard
Something to
to,
consider.
It's a tough scenario. Like I said, my clients have been here 50 years, and they've been quiet people until very recently. This has become an issue, and they really need to, they really feel compelled that this would establish what they bought initially, which was the privacy they had, albeit not with the house there, of course. Development happens. But it has become a tense situation, and there's some friction between the neighbors. And that's, again, what we're trying to avoid. And it's not that we need the highest fence in the world to accomplish.
Still achievable by a conforming 6-foot fence, in my opinion, so.
All right.
Or everybody.
it is substantial.
Well,
All right,
numerically, it's not
Looks like we have some
substantial.
folks that want to be heard, just in the interest of a long night here, sorry.
Yeah, no problem.
Anybody from the public have input?
Thank you, counsel.
Thank you. Please state your names and addresses for the record.
Charles Harmon, 51 Fenwood Road, Mayapack, New York.
You folks are going to be speaking as well?
Doris Harmon, 51 Fenwood Road.
John Newell, 44 Front Street, Mayapack, New York.
All right, all raise your right hands, please. Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do, sir. Yes.
Thank you.
How are you? Thank you for the opportunity to speak tonight. Of
course.
The reason we're here tonight is to pose opposition to the Gorelick seeking the variation of Section 156-20. My family and I are not opposed to the variation from the 4 to 6 foot fence. We are opposed from the 6 to 8. We feel it's very commercialized to the area and would be an intrusion upon us and our property's value. The consensus of myself and my family think that the fence would be very commercialized, reducing our property value, taking away the country setting we have been accustomed to in Mayapack. Additionally, such a large fence would adversely affect the wildlife, like I had indicated in my letter to you. Just some other facts here. We have drone footage. If you'd like to see we have a petition, actually. I'll just give you that first. The petition signed by 8 families, 2 in the back who butt up against this. They all oppose it. They think it's too much of a commercialized fence, too large of a fence. I don't think this wall was put in 2007 when we bought the house. This wall was not there. This wall falls partially on our property as well as the Gorlicks.
This wall you're talking about, sir?
Yes, sir. This wall was put in, as I said, by Mr. Gorlick, and our survey we had recently done, excuse me, indicates that the wall falls on both parties' property as well. I have, and again, with the grade disparity here, I put up a 6-foot fence on my neighbor's property, on my property in the boundary right there. It was no issues. It was fine. I have photos of, if you don't mind me giving them to you.
This is an, what, did you take this from the helicopter?
Took it from a drone.
Okay.
Yeah. So the area that they want to put this 8-foot fence up is a wooded area that he cleaned out a few years ago for what purposes, I don't know.
Right.
But he cleared out the wooded area, and now he wants to put up an 8-foot fence. It's kind of contradictory.
Oh, we took a ride over there. We really saw your property and how it goes. It's beautiful property.
Thank you, sir.
On all accounts, every property up there is very nice.
When was your house built?
2007.
2007.
And this wall was put in by Mr. Gorlick in 2007. We have a survey from the empty lot, and this wall was not there. We got it from the county. So this wall was put there by Mr. Gorlick, and as I said, we had it recently resurveyed, and there's portions of this wall that do fall on our property as well, so any disturbance to this wall will become a legal issue as well.
Charles, do you have a problem on a 6-foot high fence?
I don't. I'm willing to work with them, and we worked with them till this afternoon.
And
where they
that's
kinda
what's
made-
allowed, John, up to,
I'm fine with the 4 to 6, and I'm fine with the 6-foot fence. I'm willing to work with them. We tried to work with them till this afternoon, and just kind of fell on deaf ears at that point.
They've lived with it for 13 years. Why now, all of a sudden, after 13 years, they want to put a fence in?
They're looking for privacy and clean boundaries, to be honest. Yeah, a 6-foot fence and arborvitae's or big greens, whatever they want to put in, would be a lot more appropriate than an 8-foot fence.
And the petition I had signed was people within a 500 square foot radius. And again, the people in the back, one owns 5 acres, one owns several acres as well. They both oppose it as well. So these are all parties that would be adversely affected by this large fence. I have a measuring tape if you want to see the actual height of an 8-foot fence. It's tremendous.
We understand that. We know.
Feet. I just want to show you, because when we all talk about 8-foot fences, it's,
it's
just look at the size.
It's higher than the door.
And again,
it's a ceiling height.
And with the regrading purposes here, the building department came out, and there was no issues with the regrading. I did it within accordance of the town guidelines. And I show there's 2 sides of the variation with the grade as well that weren't really kind of relayed properly here tonight as well. So that'd be the size of the fence that I have to look at every day. And my kids are out there too, and I have kids. I'm also concerned this is an elevated area. The wind catches the fence, it becomes a safety issue at that point as well.
Just shoot your eye out, kid. All right, do you guys wish to speak? You're good? Are you representing the same point?
My wife had the neighbors sign the petition if there's any questions that are necessary from her.
We see that. We put it in the record. Thank you.
Thank you, sir.
You're good?
We're good.
All right, anybody else wish to be heard on this application? You want to respond? Okay. Give him the podium, please.
Sir.
Oh, guys, you fill out that form so Dawn knows you guys were here and who was here.
We saw it, thank you.
You guys want to submit them for the record? Well,
Yeah, you can have, yeah, absolutely.
okay, yeah. I'll put them in the folder. All right, counsel?
Is there any identification of the parties who signed the petition and their proximity to the property?
Yeah. Hey, you gotta have this copy.
'Cause I haven't seen that, I'm just curious.
54
Thank you.
Fenwood Road, April Lottie, 54 Fenwood, David Smelling, I don't know. Eugene Steinman, John V. Nikolai,
Okay.
Ray Nikolai, and Sarah Duffy.
Got it.
All surrounding me.
I want to address one point. I have a photo in my file, but I don't have it handy. The gentleman just made reference that my client installed this rock wall several years ago. I have a photo of my client's kid, who's now 50 years old, who's about 5 at the time, standing in front of the same wall. The wall's been there before my client purchased the property when it was
Do you
vacant.
have it?
I'm going to look for it in my file. I believe I have it. But the point is, that wall's been there a very long time. And the board, again, if the board takes the position that the ground underneath that wall is where we measure 6 feet from, there's an equally compelling argument that that fence could be mounted right atop that wall, which would probably be higher than 8 feet. So there are portions right here.
Yeah, it's the common way to cheat the system, like building up a berm.
Yeah, it's not about cheating. My point is this, though. We're not coming to you tonight and saying we want to do something absurd. We're saying we want to do something a little bit less extreme than that. So for people to come out and say that this is, out of control and this is, really substantial, we're coming to you, I think, with a very reasonable proposal. And the only reason why this has been necessitated is because the neighbors that are here tonight have made it very difficult for my clients to live where they are for 50 years. So that's why we're here. We wouldn't ask for this unless we really needed it.
All right, well, if there's any in litigation or dispute between neighbors, that's not for this board. We're here to hear solely about the case in front of us for the variance, so.
Yeah, this isn't about litigation. It's just about what we're presenting, and I think it's reasonable. I really do. And I just want the board to understand that there is an absurd construction that we could have proposed, but we're not doing that. We're here to propose something that is slightly larger than what the code allows, by 2 feet. And we think that will solve a lot of problems. So we hope the board will listen to that. Thank you.
Okay.
Thank you, counsel. Motion to close?
I'll give you one more opportunity, but please keep it brief.
One opportunity here. Here is the, I guess, the vacant lot survey from the county here. I want to show you the wall and how it was relocated when we moved in. If you don't mind, I'd like to show you that to you.
The wall's really not an issue
I know,
for
I
us.
just want to kind of dispute the allegation made here. If you want
That's
to.
All
okay,
right,
don't worry
you know
about
what?
it.
It's immaterial.
Yeah, it's immaterial, so.
We hear, we know.
We're here for the
Okay.
fence, 2 foot.
All right, I'll look for a
Motion to close.
the public hearing.
So
Thank you,
moved.
Phil.
Second?
All in favor?
Aye.
All right.
Number 9.
Yeah.
Number 9. Number 9.
I just keep losing my agenda here.
Here.
You need another one?
Oh, here. Sorry.
Page 3.
Number 9, Michael A. Petrolese.
Petrolese.
Petrolese. I'm half Italian, so.
He'll tell us.
For a variation of
avoided
section
half wrong in that one.
156-5, seeking permission to retain garage. The property is located at 24 Leslie Drive, Mahopac, New York. Tax map 53.17-1-17. Good evening.
Good evening.
Mr.
Michael Petrolisi.
I knew that.
Petrolese.
I knew
And
that.
it's 24 Leslie Drive, Mahopac, New York.
All right. Right hand. Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
Thank you.
So I'm here just to hopefully retain the shed that I have. In purchasing the property in February of 2019, the garage was there. Did not know at the time it did not have a permit. So eventually I received notice in the mail. In going through the paperwork, speaking to Mike and, the team here, also needed a variance. The setback should be 20 feet. Mine is just over 11 feet.
Looks like it's been there for quite a while, so I can
Yes.
agree with that. You never got picked up on title search or what have you?
Correct, and I had questioned the title search, but even again, talking with Mike, he said there's not much we can do about it now. So just trying to
Right.
clear everything up, variance first, then permit, and hopefully
Any plans
finished.
to improve it a little bit?
Yes.
Okay.
Absolutely. Even a little
Not that
paint.
that's in our purview, just a question here, but there's no other property you can purchase to bring it into conformance?
It is not. It's a private road, so I don't think I have the right.
How long would you guess it's been there? As long as the house has been there?
The house was built in 1932. I would assume within 10,
So
15
it
years
predates
after
zoning,
that.
Yeah, it looks like it.
Got good bones.
You talked to your neighbors, no issues?
No issues at all.
No opposition?
No opposition.
Okay. Board members? Sylvia?
No questions, thank you.
Rose?
Any plans of knocking it down and just replacing it, or you're just gonna fix it up?
There was a tree that fell through it when I had purchased the property, so after clearing land, I figured out that was the hole. But in moving everything, we actually re-shingled the roof, patched the hole, and it's still got good bones. So
So you're
we're
gonna
just
keep
gonna
it?
paint it, trim it up, make it look nice again.
Julie?
No question, John.
Just watch those beehives in there, okay?
I know.
All right, any
Working around.
input from the public on this application? I'll look for a motion to close the hearing.
Motion to close.
Do I have a second? All in favor?
Aye.
All right, thanks. Application number 10, Jessica Lopez for variation of 156, seeking permission to close an existing carport to make a one-car garage. Property is located at 543 Cross Hill Lane, Mahopac, tax map 65.14-2-5. Good evening. I already swore you in?
You need to swear me in again?
No, I hope you're ready to swear me.
All right. So this property has an existing carport that's open, which you can see in the photograph. And that has a variance from 1981, I believe, and the paperwork was submitted. And the client would like to close that in and make it into a enclosed garage. And so because it's being changed, it has to go back for another variance. Even though we
Understood.
already have a variance for what's currently there.
So how long has the carport been there and closed in with those columns?
I believe since the variance was granted in 1981.
81, okay. It's not a very significant variance, it's only 4.2 feet out of a 25-yard setback. There's no property you can purchase to bring it into conformance?
No.
You're landlocked on either side. Neighbors, spoke to them on the right side? Oh, it's a corner lot, if I recall.
It's a corner
right?
lot, yeah.
But there's a house to the right side. Any opposition, discussions with them?
Not that I know of.
Okay. Silvio?
Nope.
Bill?
No questions, thank you.
Rose?
No questions?
Guys down here, we're all good?
No.
All right, any input from the public on this application? I'll look for a motion to close the hearing.
Motion to close.
Do I have a second?
Second.
All in favor? Aye. Aye. All right, good luck. What? No?
Not yet.
Take a break?
All right, application of Willowwood Country Club, Inc. for variation of section 156-24D, seeking permission to obtain a variance for the below parking requirements for the existing parking lot in association with an amended site plan application pending before the planning board. Property is located at 551 Union Valley Road, Carmel, New York, 10512, tax map 87.7-1-6, 7, and 11. This has been remanded from Putnam County Supreme Court. They're looking for 502 parking spaces, or that's what's required. What's provided is 80 standard spaces and 127 special event spaces, and the variance required was 422 standard spaces and 375 special event spaces. So this, remind everyone, the public hearing is closed on this, and we'll hear from council, I'm sure. So, good evening.
And the record is closed too, right, Greg?
That's correct. The record is closed.
Okay.
By the way, I'm George Calcanini, attorney for Willowwood, with me as co-counsel, also Charles Montalbano. Yes, the record is closed. It's remanded to this board for further action and consistent with Judge Grossman's decision. I do have Judge Grossman's decision here, if the board would like a copy of that. I have copies for each of you. Sure.
Probably like a few minutes to review it. We should really review this, shouldn't we?
Other than handing that out and indicating that the public hearing is closed and the matter is on for a decision pursuant to as outlined by Judge Grossman. I have nothing further to add at this point.
Thank you. Okay.
I can't open to the public, right, so.
Correct. What's happening now is there's no further public comment. The record, as you said, is concluded. The board's going to discuss the application. If there's motion for any action on the application, you can make the motion, get a second, and have an open discussion on that as well before you vote it.
Okay. Phil, do you want to have any dialogue on this?
Can we have a motion for a bathroom break?
Second.
Are you going to take a break now?
I'm just asking, okay, there or not.
I thought you were going to break between these two, between the application and the miscellaneous.
I go wait. I'm good. 30 seconds.
Okay.
All right, 1 second.
Yeah, I mean, Rose, you made a good point that
Yeah, we just
maybe you
got
should have had
one.
time to read this.
No, this is something we've had since December.
No.
So the decision in order you don't need to read the decision in order. What you need to do is go back in the record and make a determination on the application, okay? The decision order was sent probably back in December when it came out, but if you want to meet attorney-client to discuss what's in it, then you can take a brief recess to do that, okay?
Yeah, I'd like a few
Yes, we
minutes
do
to
that.
get some kind
I
of.
think we will,
Motion to recess.
yeah, motion recess.
For that purpose.
Don't do it-
Client
don't do it on
attorney
my account.
privilege, so. Okay, we'll take a brief recess, and we'll be back momentarily.
We're going to be back on in 3, 2, 1. You're back.
Okay, sorry for the brief recess. We needed a bio break for some, and thank you. Attorney-client privilege. So we're going to continue with Willowwood Country Club. I'm going to look for a motion.
Motion to deny.
Do I have a second?
Second.
All in favor?
Discussion.
Oh, discussion.
Discussion.
Well, on the denial. Sorry. Discussion.
Okay, I have reviewed both the September and the July 2019 meetings, and I've gone over them considerably. And I've looked at what has gone on. I looked at the self-created issue. They increased their membership without approvals. They went from I don't know how many to 202. With that being said, the parking is substantial. The amount of cars that they would need to park is an increase of 84%. The parking study that I saw, I didn't think was thorough enough. It gave a short period of time from, I think it was February through June. It lacked the amount of space, lacked the study of how many parking spaces you would need throughout the rest of the year. As it is in Dover, there was a shooting range that has closed down. With that being said, the goal of the Willowwood would be to pick up some more membership there, which is fine. But the potential for more parking, we potentially could need a lot more parking. As it is, the members are allowed to bring guests with them. So that would also increase the numbers. Just because something is happening now, you only use 80 parking spots, that doesn't mean that that couldn't change. As business picks up, as competitions pick up, you could potentially need more. A variance runs with the land. So what happens today, if we grant a variance today, the business could change over time, 2 years, 3 years, whatever. So for us to be short-sighted and give such a low number for the number of spaces, I think is not in the best interest of the community. We have to balance it all. We have to look at, all right, what is the potential here? What is the potential? Are we going to have more members if they pick up a greater membership, if they pick up 250 members, 250 members can bring in one friend each, two friends each. There could be a lot more cars coming in and out. So for us to say, well, you only have 80 spots or 127 for special events, I don't think that is the appropriate thing to do on a long-term basis. Like I said, a variance runs with the land, and it could be potentially 5 years from now that it's a much more active shooting club, and there could be a greater need, and we could be running into potential problems there with the amount of people. So I believe it's a self-created issue when they increase their membership. I think it's substantial. They are operating already, and we're balancing what could potentially happen. If they have a competition which is much greater, if they decide to expand the number of trying to think what they called them. Stations. If they decide to increase their stations over time, that could definitely increase the number of people that could be coming. There's always room for expansion, and I think for us to agree to such a small number of spaces is not in the best interest in the community. Again, potentially, if there aren't enough spaces, there could be an adverse effect on the traffic, on the area itself. That's my opinion. I don't know how everybody else feels.
So I'll go next. I think it's obviously the difficulty is self-created because they went and they increased their membership, so that's an easy one from a weight test. And again, I'm only one member. Is it substantial? Yes, I think we've established the fact that the number is large and substantial. And the fact also that, you know, as Rose said quite well, the variance runs with the land. Once we grant this, the genie's out of the bottle. We can't ungrant this variance. And it is quite substantial. If something changes with the use of the land, then we run into issues. Is there any other method of doing this? Sure, don't increase membership and everything is fine. So again, that's a 3 versus 2. Undesirable change to the character of the neighborhood? No, the shooting range is there, continues to operate. I can't allow that to you know, at least for me. And will it have an adverse effect or impact? I don't think so. But in my mind, it's 3 versus 2 against the granting of this variance. So for me, I have to agree with the denial. But again, I'm just one member. But that's just for the park.
I want to thank Rose for going through it, and I think she really hit everything on the head. The one thing I'll disagree with Silvio is that we have the 5 factors for the area variance, and it's not, we have to consider them and we have to balance them. It doesn't mean a 3 out of 2 win.
No, fair.
It could be 2, it could be 1. And in this case, we're looking at, I think, there's 2 the factors that really carry the day. The self-creation, yes, with, you know, as we discussed with the increased membership, and the substantial variance that we're looking at here. It's just the numbers are fairly large, 80 to 422, 127 special event spaces to 375 special event spaces. And for that, I would be in favor of the motion. Thank you.
All right, Julie, John, John is more involved than last time. You guys in agreement with what's been presented?
With Rose, yes.
Julie? Okay. All right, so I guess I'll do roll call vote here. Silvio, you for the motion?
For the motion as presented.
Phil?
For the motion.
Rose?
For the motion.
Julie?
For.
Four.
Phil? And I'm for the motion as well. So it stays as decided. All right, getting back to the agenda. On application number 1, Mayhoven, I'll look for a motion.
Motion to grant.
Do I have a second?
Second.
All in favor?
Aye.
All right, number 2, Galeno Enterprises. I'll look for a motion.
Motion to grant.
Do I have a second?
A second.
Any discussion?
The
Wait, hold
mixed,
on. What are we granting?
this is on the mixed use.
Hold on.
Galeno.
Galeno.
Right, there's 2.
There's 2
Oh,
parts
I'm
here.
sorry.
There's the interpretation.
There's the interpretation use variance. Like, what are you
All right,
doing?
let me
Oh,
go
yeah,
back.
yeah.
I'll go back, I'm sorry.
All right, so rescind, you rescind your...
Yeah, I'm going to rescind, I'm
motion.
sorry. It's been a long night.
Yes, yes. All right, they're seeking an interpretation that the CO issued for upstairs residential apartment remains valid in that the temporary conversion to office use involved no structural alterations. So interpretation is what? What's your motion?
My motion is not for the interpretation.
Are we doing this right?
Not for the
Yeah, it's either to grant or deny the interpretation.
My motion is to
That's
deny the interpretation.
All right.
This would be the order of operations.
Do I have a
for the
second on-
interpretation first.
Second.
All right, any discussion on that? All in
That's to
favor?
deny, I'm sorry, to deny.
Deny the
He
interpretation.
lost the use. Basically, we're saying he lost the use. That's what
All right.
the denying the interpretation says.
So all in favor on the denial?
Aye.
Aye.
Okay, so,
Now there's the use variance.
All right, so my motion is for the use variance.
okay, do we have a second on that motion?
Second.
Any discussion?
The use variance, there's 4 factors, and all have to be proven, and I believe counsel, when he presented his case, did. There were financials that were provided that showed that it was incapable of earning a reasonable return. Property is affected by a unique or at least highly, not uncommon, but
Unique, for
a
sure.
unique circumstance. It will not alter the essential character of the neighborhood. It's been there forever, and it's not self-created. As a matter of fact, this is something I think the town is looking to do, to have this kind of residential over commercial setups within the county. So I
That's
think,
the master plan.
yeah, I went to one meeting and I learned all of that. So I believe that all the factors have been proven and that the use variance should be granted.
Any other input on that?
No, I agree with it. I think Phil said it well, so, for me.
All right.
Residential is far more restrictive than to have a commercial use. And given the amount of parking spaces, I can't see them continuing the commercial use of it.
Yeah, they presented that as such.
Right.
All right, let's just do roll call on this. Silvio?
For the motion.
Phil?
For the motion.
Obviously, Rose?
For the motion?
Julie?
For.
John?
For the motion.
For. And I'm for the motion as well, so it carries as such. Number 3, Zelli, I'll look for a motion.
Motion to grant.
Do I have a second?
Second.
Any discussion?
In light of the easement, a full variance of 10 feet is, I wouldn't say necessary, but it's appropriate.
Judging from the fact that the deck's been there so for however long.
And the parties agreed.
And you're right.
They were in
it's been
court and
agreed.
agreed to it. I agree with Phil.
If there was no court order and there was no signed stipulation by both parties that were here, including councils, if we had a letter from them saying that they were okay with it, we would have granted it. So I don't see the difference.
Okay. Let's do a roll call vote, just in case, John, for the motion.
For the motion, for the variance, 10-foot variance.
Bill?
For.
Julie?
For.
Rose?
For.
Bill?
For?
Sylvia?
For.
And I'm for the motion, so carries as such. Number 4, CRM properties.
That was held over.
Sorry, yes.
Yeah, we
held
held
over.
that.
Number 5, Yang, look for a motion.
Motion to grant.
Second.
All in favor?
Aye.
Granted. Number 6, Hovis.
Motion to grant.
Seconded.
Any discussion? No. All in favor?
Aye.
Number 7, Serio, look for a motion.
Motion to grant.
Do I have a
Second.
All in favor?
Aye.
Number 8, Gorlick, do I have a motion?
Motion to deny.
Do I have a second?
Second.
Discussion?
No, I
Yes,
think
so-
it was
Discussion, hold on.
significant. It was a significant, not the fact that it was 2 feet, but the fact that it spanned 235 feet, I think.
Yeah, we're
That-
talking a 235-foot fence that's going to be, if I'm correct with my math, 33% of a variance. And, I understand the applicants have been living in that area for 50 years, and the neighbors have been there for, if I recall, more than 10. And I don't know, what's going on out there, but to have that kind of a fence, that length, that height, I don't see it. But the factors for the variance, whether
They're
it's
just about to read them here.
So tonight, you're going to read them?
Is the proposal variant, will an undesirable change in the character of the neighborhood or a detriment to nearby properties be created by granting of the variance?
And I would say yes, it
Yes,
does.
it looks
I
like a
would say so,
commercial, the type of fence and the size of the fence makes it look like a commercial property. Can any other method be used that does not require variance but still allow the benefit requested? Yes.
Yes.
Screening, greenery,
6-foot
shrubs, what have you. Rocks even. Is proposed variance substantial?
Yes.
I would say so.
Yes, going from 6 to 8, when you're talking about a fence, even as the folks here put a tape measure up against that wall, it's pretty high. Will the proposed variance have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district?
I think in the environmental, absolutely.
Yeah, if the neighbors testified that the wildlife do cross that property along the lot, maybe more difficult over an 8-foot fence, so I think they even made an environmental argument.
And is the alleged difficulty self-created?
No.
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 Doesn't need
Balancing
to
the
meet-
factors
Doesn't need
out.
to meet all, so.
And using Silvio's 4-to-1 rule.
Okay, roll
Sorry,
call.
Counselor, I didn't-
Roll call vote. Silvio?
For the motion.
Bill?
For the motion.
Rose?
For the motion.
Julie? Bill?
For the motion.
For the motion.
I'm for the motion, so it's denied. Sorry, Number 9, Petrolisi.
Did you say it right this
Look
time,
for a
Jeff?
motion.
Yes, he did.
Petrolisi.
Motion is granted, motion to grant.
Second. Any discussion? All in favor?
Aye.
And number 10, Lopez. Look for a motion.
Motion to grant.
Do I have a second?
Second.
Any discussion? All in favor?
Aye.
All right, minutes from November 19th, 2020.
Motion to accept?
Second.
Second, any discussion on that or changes? All right, all in favor?
Aye.
December 10th, 2020.
Motion to accept.
Do I have a Second by Julie. All in favor?
Aye.
Okay. Thank you, everyone. Good night.
Motion adjourned.
Hold over case.
Motion to adjourn, Johnny.
Motion to adjourn.
Otherwise, the meeting's still going.
3 hours later.